My name is Keith Ivey, and I direct the Institute for the Study of Judiciary, Politics, and Media here at Syracuse University. And IJPM, in collaboration with the Carnegie Legal Reporting Program, directed by none other than Mr. Hansen, that fellow right there in the suit and tie, Roy Gutterman. We collaborate together, Carnegie Legal Reporting Program and IJPM, every year, and bring to campus a range of speakers, both from the academy and from the bench, bar, and the press, to discuss issues at the intersection of law, politics, and media. And today, for our final lecture, we are fortunate to have James F. Haggerty. Mr. Haggerty is a practicing attorney, litigation communications consultant, and an author of the book In the Court of Public Opinion, Winning Strategies for Litigation and Communication. It was just published in 2009 in its second edition form, so it's already entering multiple editions here. Mr. Haggerty is the owner and founder of the PR Consulting Group, an internationally known litigation communications firm that has worked on some of the largest cases of their kind in history, including the Corbell Indian Trust class action, which is the largest class action ever filed against the United States government. The Wertheim department store litigation, which is considered the largest single-family Holocaust restitution claim in history, involving land in downtown Berlin used to construct Hitler's bunker and the Reich Chancellery, and product disparagement claims against Consumer Reports magazine by Suzuki Motor Corporation over the Suzuki Samurai rollover incident and Sharper Image over reviews of Ioniq 3s. As an attorney, Jim has been involved in consumer cases related to such issues as the presence of dangerous chemicals in soft drinks and the marketing of videos claiming to enhance the cognitive ability of infants and young children. Anybody know Baby Einstein? Most recently, he's an attorney for plaintiffs in the Toyota sudden acceleration litigation, and he's also outside counsel to a green investment company with investments in recycling, real estate, and clean tech industries. Today, Jim is going to be talking to us about litigation communications, which is something of a growth industry in legal practice in the United States. And it's also an area of activity that really unites law and media in a practical, on-the-ground way. We're very fortunate to have Mr. Haggerty with us today, and I ask you to join me in welcoming.
Thank you, and thank you, Keith, for that kind introduction. Let me start off by saying it's a great pleasure to be here and to be back. I actually spoke last year. It's always a good sign when you're invited back to speak someplace. At the outset, I also want to compliment Syracuse and the law school and the School of Public Policy and Newhouse for putting together a program like this. You know, there's a lot of talk recently about what law students actually learn in law school and how applicable it is to practice once they get out. And I'll tell you, this is one of the areas that you see more and more of the confluence of law and media and public opinion. And there are very few schools, and believe me, I've checked, that really look into these issues the way Syracuse does. It should be commended on that. Because obviously, from my standpoint, I believe that media, politics, public opinion, and other extrajudicial forces exert an enormous pull on the litigation system and the ultimate resolution of legal disputes. And you know, as a result, they exert enormous influence on truth and justice and all the things that we value as the underpinnings of our judicial system. All of that is coming together and integrating, and I can use my own background as an example. You know, I went to school to study journalism, eventually wound up in government, handling public relations, then went to law school. Practiced a little bit, this was the early 1990s. Realized that I was probably more valuable to the lawyers for my public relations skills than for my legal skills. And I don't know quite what that said at the time about my legal skills, except that there were very many people who could write a brief or conduct a deposition. So what is public relations? Where part of my unique selling proposition, as marketing people call it, was my background in law. You know, I had this legal background that could be used for public relations. Flash forward 10, 15 years, I now find myself being hired as an attorney, and my unique selling proposition is my background in public relations. And while this may make some legal traditionalists shudder a little bit, this is the way the practice of law is changing, for better and for worse, or for worse. You know, it's evidence of the integration of all these issues. It's all coming together. And it's the lawyer's responsibility to understand how it's all coming together, what it means for their clients, and what it means for the ultimate administration of justice. Now, I understand that your prior presentation dealt with public relations and its value, if that's the right term, to society. And certainly I'm going to reinforce that notion, I hope, but from an advocate's perspective on the importance of using public relations. You also had a writer from Law and Order here a few weeks ago, and which is interesting, and I will tell you that you often hear that what you see on TV about law and legal programs has nothing to do with the practice of law in the real world. And I will tell you that you see things occasionally in the courtroom that you say, you know what, if that was on Law and Order, the audience would say, I don't believe it, that's too sensational, that's too crazy. So don't discount the way what you see on television is beginning to affect the legal process and vice versa. In fact, one of the lawyers I interviewed for my book, who became a friend, Mark Lanier, who is a lawyer, probably one of the best-known trial lawyers in the country. Among other cases, he handled the Vioxx case in Texas that wound up with a $253 million verdict. He tells me that he tries to make his trials more like television instead of less like television, because the perspective of the jurors comes from what they see on television. And so if they go in as a juror and sit down and say, wow, that lawyer is just like I saw on television, the implication is that lawyer must be good. And again, I don't know how valuable that is for our society as a whole, but I just pointed out as one of the ways in which all of this is coming together. Now, the other interesting thing that Mark tells me is that although he's the most famous trial lawyer in the country, or among the most famous, he occasionally gets called upon, and more often gets called upon, to handle the media frenzy in a particular court case. So instead of hiring him for his trial skills, they're hiring him for his legal skills. And I think he's beginning to see the way all of this starts to come together. Another example would be in and it's in my book as well, the Duke Lacrosse rape case, where one of the defense lawyers, Joe Cheshire, who handled that case, told me he was spending 4 to 5 hours each day on the phone with media, trying to explain the defense of his clients. Again, all of that comes together in the work that I do and some of the things I'm going to talk about here today. And by the way, the two other points I want to talk about how the real world does not imitate television. One is that in an hour-long drama, you don't see all of the massive number of documents and communications going back and forth between each side and then to the courts. All of that is sort of eliminated. And the other part of it you don't see is the fact that most cases don't go to trial. In fact, statistics show that 95 to 98% of cases settle before trial. Now, most of what I do is in the civil context, or if it's in the criminal context, not necessarily a homicide, but more of a fraud case or a regulatory investigation. But it's equally applicable in the criminal process where most cases are pled out. So when you talk about litigation in this country, you're not talking about the big trial before the jury. Ultimately, what you're talking about, in most cases, is a process that gets resolved short of trial. Ultimately, therefore, the court of public opinion might be the only place where these issues are ever resolved with some finality. So those are a few things I just want you to keep in mind as I begin to go forward. So you have this remarkable confluence of all of these issues. And I would point out that another thing that they don't necessarily teach in law school or when teaching about the litigation process is the concept of the cost-benefit analysis. and again, I went to law school a number of years ago, but I think it still holds true. In any piece of litigation, the litigant, be it an individual, a corporation, a prosecutor, a plaintiff's lawyer, makes a value judgment, a cost-benefit analysis before deciding whether and how hard to assert legal rights. In other words, what would be the cost of proceeding through the legal system to protect my rights or assert my rights? Whether you're asserting a meritorious claim or defending a claim that has no merit. What will be the cost and what will be the benefit? How hard should I fight? What resources should I devote to this? If you're a corporation, how much of a priority are you going to make this case over the many others that you're being hit with on any given week or month or year? I've seen statistics that corporations have 3 lawsuits filed against it each week. How much of a priority is this going to be? How much of your resources is going to be devoted? Will you throw your best people at it? Will you hire your best law firm for this case? It's all a cost-benefit analysis. When will you settle? How hard will you fight before settling? Will you pretend to fight knowing all the time that you're going to settle? On the plaintiff side, a big question is, do I have the resources to bring this case forward? For a plaintiff's lawyer, the question can be, is this case worth my time? Is there a significant enough chance of winning for me to invest my resources and time for a case that may ultimately lose 1 or 2 years down the line? These are all the practical applications, practical considerations that go into whether to file a lawsuit, how hard to fight, and how long to fight. And that's probably more true than in a civil litigation than in a criminal court case when you've been arrested for murder, I suppose. But the ultimate fact is that even in very many criminal cases, the prosecutor is making a decision on how hard to fight based upon many of those same factors. And I'll talk a little bit about the SEC lawsuit against Goldman Sachs. But right now, lawyers at the SEC are trying to figure out how hard to fight this thing and where it's going to wind up. And then there's the reputational considerations. And this is where my work tends to come in. What is this lawsuit going to do to my reputation, to the reputation of my company, to my reputation as a prosecutor, as a regulator? All of those factors go into consideration. If you're a company, is it worth proceeding? What will it say to my customers, to my business partners? If I'm a public company, what will it say to the investment community, to my shareholders? All of these reputational considerations figure into whether a lawsuit will be brought, and then ultimately how hard a litigant will fight. And so part of what we do during this process is get facts and information out there in a way that influences the ultimate cost-benefit analysis that goes into these cases. And again, part of the calculation is how do you use the tools of communication in its broadest sense to influence the course of the case and ultimately the cost-benefit analysis that goes into it. And again, it's a gray area that exists between legal strategy, media strategy, politics, and policy. And that's where litigation communication comes in. And I often feel like I could speak for hours on this topic, and I promise you it won't, because it's so interesting, and there are so many nuances, and there are so many jumping off points, and there are so many ways to approach the issue. And that fact reminds me of something that I always think of, which is that it's a lot easier to state your case in 10,000 words than it is to state it in 1,000. Anyone can make an argument in 10,000 words. If I sat up here for 6 hours, I could convince you of the value of what I do. It's a lot harder to do it in 1,000 words. It's even harder to do it in 100 words, even harder in the proverbial 10 words or less. But when that is what's happening when you're communicating during a legal dispute. In the media age, we're all awash with information. And you see it, I think about the changes from when I went to college and law school, and one of them is that people weren't walking along texting as they went between classes back then. Now it's a wonder they don't get run over on the way class. The world has changed. We're awash in information in ways that we weren't even 10 years ago. And so how do you discuss intelligently and coherently a lawsuit with hundreds of legal filings, with millions of documents attached to it, with thousands of different arguments in the various parts of the case, and how do you do it in the proverbial 10 words or less? And this is what we're doing in the litigation communications field on behalf of our clients. It's not that different from what lawyers do in the courtroom. You take a voluminous amount of information, you distill it into a story and a storyline that you're going to present to your audience. In the courtroom, it's the jury. Outside the courtroom, it's all of the various audiences and stakeholders that will impact both the course and conduct of the case and the litigant's reputation. So you really have to look at how to position issues and arguments, how they will form perceptions based upon the information that you provide. How do you change perceptions that have already been cemented in the public mind? And I'll talk about the Goldman case as one example, but in every case involving a prosecutor, a regulator, even a plaintiff's lawyer, they get the first bite of the apple. They get to describe the case initially to the filters, the media and other audiences that will ultimately determine what the public hears and sees and knows about a case. How do you change perceptions after that happens? Spin doctoring, or spin, is the pejorative term that's often used, but it's really not about that. It's really about taking the vast volumes of information, finding the story, finding the nuggets in there, and presenting them in a coherent fashion to your target audience. Now, are you presenting it the way an advocate does? Of course. No different than a prosecutor is when they present their side. But what you're doing really is trying to sum things up in a form that everyone can understand. And so this cost-benefit analysis, it informs what you're doing down in the trenches. And again, all of it will have an impact on what people perceive. It's not necessarily arranging press conferences. It's really figuring out what you're going to say when you get to the press conference. And lawyers, and certainly public relations consultants, but lawyers are increasingly understanding, and they really need to understand how all of these forces affect legal disputes. Because whether you're a reporter, whether you're a public relations consultant, whether you're a lawyer, whoever you're representing, if you don't understand how all of this is impacting the ultimate resolution of disputes, it's hard to be great at what you do. And I think that's as lawyers are beginning to realize slowly that is the case. And I would make no bones about it. I believe what happens in the court of public opinion can be as important, if not more important, than what happens in a court of law. I realize that that's a bold statement, but in many cases it's true. And lawyers and clients are increasingly realizing it's true. And hopefully, good advocate that I am, by the time I'm done here, you all believe it's true. But consider this quote that, from a 1991 case called Gentile v. State Bar of Nevada by Justice Kennedy in his decision. And I'll read it straight here. An attorney's duties do not begin inside the courtroom door. He or she cannot ignore the practical implications of a legal proceeding for the client. Just as an attorney may recommend a plea bargain or a civil settlement to avoid the adverse consequences of a loss at trial, so too an attorney can take reasonable steps to defend a client's reputation and reduce the adverse consequences of indictment, especially in the face of a prosecution deemed unjust or commenced with improper motives. A defense attorney may pursue lawful strategies to obtain the dismissal of an indictment or reduction of charges, including an attempt to demonstrate in the court of public opinion that a client doesn't deserve to be tried. Now that case is from the criminal context, but certainly it's as applicable to civil cases when parties are fighting over money or property or rights. And I'm going to, obviously there are ethical dimensions of this, which I'll talk about in a few minutes. But I think the key point is the attorney's duty does not end at the courtroom door. I think more and more attorneys are realizing this. And by the way, this case is from 1991. Before the internet was the main source of news for most people. Before the O.J. Simpson trial, put coverage of lawsuits on the front burner of the public consciousness. And before the explosion of media, both traditional media and new media, that now saturates all aspects of our lives. And by the way, I think the distinction between traditional media and new media, or even social media, is quickly disappearing. I think that the days when you could divide everything up into the old media, the New York Times, the Wall Street Journal, the broadcast networks, and blogs and internet websites and Twitter and even Facebook and MySpace and stuff. Those distinctions are disappearing. I find, for example, that blogs are very much becoming a reliable source of media, a source of media as reliable or more reliable than the mainstream press at times. They're able to go more in depth into issues. In a way, they become the trade media of the new millennium. All of the media, whatever the form, goes into how the public perceives your case in the court of public opinion. And it has an enormous impact on how cases are perceived in their ultimate resolution. So again, I mentioned it's not all about press releases and press conferences, but what do we do to present this case effectively in the court of public opinion? And then, like I said, there's a lot of misconceptions. It's not arranging the press conference on the courthouse steps. It's not late night arguments on Nancy Grace. It's not setting up interviews on 60 Minutes. All of that can be part of what we do, but that's not the essence of what it is. Most of it is much more nuanced. Advising on the public implications of a case. Advising on your response and what it will mean in terms of both your reputation and the way a case proceeds. How your reputation can affect the course and conduct of a case, both in a positive manner or in a negative manner. I'll give you another example from another attorney I interviewed from the book, a guy named Bill Ohlmeyer, who is now at the firm Boies Schiller, but had been at Altria Group, the former Philip Morris, the tobacco company, who obviously had seen a bit of litigation or two in his day. He put it like this: if your teenage daughter comes home at night, late on a school night, and you ask, "Where have you been?" and she says no comment and runs upstairs, you're going to make some assumptions about what's going on. And if she walks in and says, and you say, "Where have you been?" and she says, "Well, let me get back to you. What's your deadline?" and runs upstairs, you're going to make a different set of assumptions. But if her response is, "Look, I made a mistake. I'm sorry. I think I know what I can do not to let this happen again," those sentences are going to change the whole tenor of the conflict. And that sounds simple, and in a way it is, but doing it well in the course of a legal dispute is hard. That's where the art and science of this practice of litigation communication comes in. I always compare it to Willie Mays playing the outfield. The outfield wasn't any easier to play, he just made it look easy when he was out there. And how you respond publicly is going to have an enormous impact on all of this, and especially on the other side. And you know, the whole no comment thing reminds me of the most recent SEC lawsuit against Goldman Sachs. And if you're following the twists and turns of that case, you're seeing an amazing showcase for what not to do, and then how to pull yourself out. For those of you who don't know, the SEC sued Goldman Sachs on a Friday, just about 2 weeks ago, or maybe a little bit less, alleging they didn't disclose a fact about these complicated synthetic CDO investments. And the fact was that a hedge fund owner who was betting against these investments had helped put it together so that it would fail, hoping that Goldman could then sell it to an institutional investor, and when it failed, the hedge fund manager would make money. So the SEC announced its lawsuit after trying to negotiate a settlement with Goldman Sachs, and there's no real explanation as to why Goldman Sachs didn't see it coming, but they didn't. And the SEC announced the lawsuit with a big press release and with copies of emails that had gone back and forth that were certainly sensational in nature. And again, Goldman Sachs was caught flat-footed. They said nothing for several hours as the story began to sink in with the media. Then they issued a very short statement, just a few sentences long. They said they believe the suit is meritless and they will defend themselves vigorously. And by the way, those statements, I talked about no comment. Those statements, this suit is meritless and we will defend it vigorously, those are becoming more and more the no comment of the modern age. Everyone has learned that, hey, don't say no comment. So everyone falls back on, we believe this suit is meritless, and we will defend it vigorously. And you know what, just like no comment, you sound a little guilty when you say things like that. As if you were going to say, you know what, we think the suit has a lot of merit, and we probably won't defend it much at all. You know, I think that the other point is, they don't say, we didn't do it. They say the suit is meritless. It's almost as if they're saying, hey, we did it, but we don't think there's a legal basis for you to come after us. Those are the types of messages you're sending out in a statement like that. And by the way, in the Goldman case, as you all know, nobody believed it. In the first day, their stock dropped 13%. You know, and as a result, the company's market capitalization lost about $12 billion. And again, go back to the cost-benefit analysis we talked about, and the relative value of losing in the court of public opinion as opposed to losing in the court of law. If the SEC charges are ultimately proven, the fine will be in the millions of dollars, probably in the low millions of dollars. Fumbling things in the court of public opinion, Goldman Sachs lost $12 billion in a single day. And you know, perhaps you think, well, there's very little that Goldman Sachs could have done to defend themselves in this situation. I mean, particularly, and again, I don't want to judge their relative guilt or innocence, but particularly given the fact that certain financial institutions seem to have done certain very unscrupulous things over a certain period of time. And how's that for a PR stunt? But right now, what they're in the process of doing the sorts of things they should have been doing right away. And it may, the jury is still out as to what kind of impact it will have, but you can see the process developing as time passes from the initial announcement of the lawsuit. I mean, first they issued a second, more detailed public statement over that weekend. In fact, it was about 4 pages long. It went into detail about the particular investments, how isolated this particular product was, how this is not something Goldman Sachs, which did presumably millions or billions of trades a year, did a lot of, and how they would never allow someone to bet against their clients and not inform the client, a sophisticated institutional investor of that. You know, then into the next week, they took the very unusual step of, during their quarterly earnings call, making the general counsel of the corporation available. Usually during an earnings call, the company CEO and chief financial officer will explain the financial performance of the company. Goldman Sachs took the very unusual move of also having the GC there, because they knew during the earnings call most of the questions would be asked about the SEC investigation. And throughout he insisted that Goldman would never knowingly sell out their clients. That same week, there were 2 scoops on CNBC. Again, this is just last week. Just timed just a day after the general counsel's appearance at the quarterly earnings call. So the CNBC reporter broke in at about 8 a.m. to say we have breaking new information exclusively on CNBC about the Goldman Sachs case. On one day, it was the fact that the hedge fund manager's advice on which investments to pick was rejected more than half of the time as this product was put together. The second was that the institutional investor who eventually bought the product knew that the hedge fund manager was involved. They also have begun to place advertisements explaining their side of the story. As far as I can tell, they are also rounding up third parties to write op-eds and opinion pieces explaining their role. Slowly they begin to chip away at the original storyline, the original mistake they made in not responding quickly enough with enough information to frame the story in the public's mind the right way, or in their way. I shouldn't say necessarily the right way in this case. Will it work? We'll see. There's going to be a tough week this week when the chairman of Goldman Sachs appears before a congressional committee. And there'll be a lot of hoopla, circus surrounding that. And how they respond will very much impact the course of the case as well. But here's the point. I can imagine 2 weeks ago on a Friday afternoon, lawyers at the SEC high-fiving and congratulating themselves for how great the news of this suit went over. And I can also imagine those same lawyers a week later beginning to think, boy, I wonder if we do have a case here. Because prosecutors and regulators believe what they read too, even about their own cases. And they're going to make a value judgment as to how hard they fight on their end, what they will settle for. And the question becomes, when everyone gets in a room to discuss the settlement of this case, who's going to feel they have the upper hand? If you go into a settlement conference, one side's been beaten up for 6 months, the other side has seemed like a hero, you're going to get very different terms of the settlement of that dispute than if you fought each other to a standstill, or if the other side has come out. And you'll see, by the way, the same thing in the Toyota case, which is a case I'm involved in. And I will say that what you will see in the Toyota case is that the ultimate resolution is not necessarily determined by the bad news that happened in the first 2 months of this year. What's going to determine whether or not, in the plaintiff's view, Toyota makes right in this case is whether it's still in the public mind 2 months from now, 3 months from now, 6 months from now. Because it's a classic defense tactic to deny, and hope some other case comes along to knock you off the front page. And from a plaintiff's standpoint, I often tell plaintiff's lawyers, one news conference on the courthouse steps is not going to win this case for you. What you need to do is step by step show the world the rightness of your cause, the rightness of your case, and convince the other side that neither you nor the case are going away. And as a plaintiff suing a large corporation, for example, you know that their strategy is to see how you're going to feel about this case 6 months, a year down the line after you've exhausted your resources. The more you can convince them that you're still going to be here, the more they're going to think, you know what, it's easier to get rid of this case than to keep it going. I'll give you an example from the Holocaust restitution claim I was involved with. which was a grandmother in New Jersey who woke up one day, and this is the literal truth, and again it gets back to my point that you can't make this stuff up, woke up one day to discover she was the heir to the largest single fortune that had been taken by the Nazis, and included the land in downtown Berlin that was used to build Hitler's bunker, the Reich Chancellor, and many other buildings. She had no idea. They escaped Germany earlier. As was often the case, her father didn't talk about what had happened. She grew up on a chicken farm. Found she was at the heart of this giant Holocaust restitution plan. She was also 78 years old. And the corporate defendants in Germany knew this. So one of the tactics during the litigation was to send her over to Berlin with her 2 grandsons, so that they could appear before the German press and say, here's a new generation that's going to make sure right is done long after I'm gone. And those were the 2 young grandsons who appeared on the podium with her. Lo and behold, both the government and the corporate defendant began to realize it was a case that was not going to go away. And ultimately, they sought a resolution. And so everyone is impacted by the perceptions around them, and particularly during the legal process. And you're seeing evidence of it everywhere. You know, what is what is read, what is said, all of that goes into the ultimate construct around which you build your perceptions about a case. Now, Professor Bybee in the introduction to the book you gave me last year mentioned the enormous, and I think this is the basis of all the essays, the enormous fear in the public that judges are influenced more by their political beliefs than by the law or what should be done under the law. And there's a great fear out there in that. But it's also the case that judges are influenced by the totality of their experience. And that includes what they read and what they learn about publicly about all of these issues. And then, of course, there's the issue of the jurors. Now, most cases settle, but jurors have been known, even during the course of a trial, to be influenced by what's happening in the courtroom. And sometimes they do that by going home. Now, most cases are not sequestered. Most cases, you're not in a hotel room without access to television. You go home at the end of the day. And a lot of jurors go home and they watch CNN and they surf the net and they often read about what's going on in their own case. You know, there's a famous case from last year where jurors in a big drug trial in Florida, one of the jurors admitted to the judge that he'd been surfing the net to learn more about the case. And so the judge polled the rest of the jurors. Turned out that 8 of them had all been doing the same thing during the case, and the case was ultimately thrown out. It goes on with juries all the time. But don't let that dissuade you from the fact that it goes on with judges and as importantly, their clerks as well. Everyone is influenced by what happens around them. And so you have to start thinking about your case in terms of that influence. I worked on a case recently where, for scheduling purposes, there was a big gap between the plaintiffs putting on their side of the case and the defense putting on their rebuttal, a gap of several months. And it created a terrible situation in terms of public perception, because you basically had a situation where the plaintiff could present their side, both in the courtroom before the judge and in the media. And then there'd be several months where that would sink in before the defense would even have a chance to respond. Created enormous difficulties, and we had to figure out a way publicly to influence perceptions of the case so that when the judge and the judge's clerks went home after hearing the plaintiff's case and read the newspaper, they weren't immediately thinking, you know what, it's true. Plaintiffs are writing this. And we had to keep it going for several months until we were able to present our case. All of this, and by the way, I would add, that was a bench trial, not a jury trial. And you have to worry about the judge. A lot of cases, many cases, are not before a jury, but before a judge. You have to worry about the judge. You have to worry about the judge's clerks. So you're not calling press conferences at the drop of a hat. You're not issuing a press release for every decision of the court. I remember one case in the internet era where the judge allowed a continuance for one side to collect more evidence. He basically postponed the case for a month to allow the one side to do things. Very routine procedure. You know, you can do it for scheduling purposes, you can do it because you haven't garnered enough information. The party that had made the motion and won issued a press release saying, you know, judge grants our side's motion. And it went out all over the media, even though it was as routine as breaking for lunch. Needless to say, the judge was not happy. When they went back in the courtroom, he certainly told that side so, and the case did not go well as a result. So I'll give you an example of how this works in action. And it comes from an employment discrimination case I worked on several years ago. You know, I'd just gotten back from lunch and received a call from a man I didn't know. His English wasn't very good. It was a Japanese company with a U.S. affiliate. I had a little trouble understanding him. And he said, look, Mr. Haggerty, we've been referred by lawyers for our company. We have a little bit of a problem here, and there's a news crew who wants to interview me about it. And I said, well, where is this news crew? And the man said on the other end, they're standing right next to me. Now, at this point, I have no idea who the man is. I have no idea who the company is. I have no idea where the news crew is from. I have no idea what the issue is. But what I do know is that if the company responds poorly, if they do the no comment, if they throw the hand over the camera lens and have security escort the news crew from the building, you're probably going to make a lot bigger story out of whatever it is that we're dealing with here than if you figure out a way to deal with it. Again, same facts, same law, very different way of dealing with things. So what I did was I told the man to put me on hold, escort the news crew into a conference room, sit them down, see if they want water or coffee, what have you, and then come back and get me on the phone. As he was doing this, the lawyer who had referred us called and explained what was happening. It was a very difficult situation. An employee had settled a discrimination complaint and then committed suicide 2 days later. A very acrimonious, difficult situation, horrible set of facts. And you know, there's not a whole lot you can do to make that better. But what I can tell you is there's an awful lot you can do to make it a lot worse. And throwing the news crew out in the street would have been one of those things. And so while the news crew was waiting, we got the company's lawyer on the line and the company executive on the line. And the lawyer, very traditional in his outlook, didn't want to say anything. Just say no comment. And so I said, look, can we offer condolences? Oh yes, I guess we can. Can we say we're saddened by this tragedy? Oh yeah, I think that's okay. That we're still gathering information about what happened. Yeah, we're still doing that, so that's absolutely what we're doing. And then in certain states, it's illegal to discuss an employee's personnel records. So we could say that, you know, it's illegal in this state to discuss, publicly comment on an employee's work record, so we're not going to do so. There was a pause, and we said, you know, we can say all of that. So that's what we did. We put together a statement with that information. We went to the news crew and said, look, no one's going to appear on camera, but we're going to give you a written statement about what happened. And they agreed. Now, they got what they wanted. You know, they could film the outside of the building, they could flash the statement up on the screen. And more importantly, we got them out of the building. You know, does it always work that way? Or work that well? Probably not. You know, and we didn't say much. Our statement didn't say much, and it said things that had nothing to do with the legal claims or the issues at the heart of the case. But that's not what people are going to be interested in. In most cases, what people are interested in during a lawsuit is not what's legally significant. It's what is the story behind this case. And by the way, in a more recent case, actually a more recent case with a potential client that I didn't take, one of the comments was, boy, you say you're sorry an awful lot in these statements. And, my response to the company is, you know what, if more companies said they were sorry, they'd have a lot fewer public relations problems. And I think you see that borne out every day. That's like the story of the 14-year-old that comes in late. You take a potentially disastrous situation, you make it manageable. It's still bad news. A lot of the work I do is in very difficult situations and in very bad news situations where you're not going to spin it in a manner that has the company, smelling like a rose. And let's face it, corporations do bad things. Their employees do bad things. It's the old, but think about the old Nixon phrase, Nixon maxim. It's not the crime, it's the cover-up. You'll see it in the Goldman Sachs case. You'll see it in the Toyota case. In the Toyota case, it's not necessarily the instances of sudden acceleration that are the problem. It's the fact that the company hid them for so long. It's not the crime, it's the cover-up. All this brings me to my final point, and I'm going to take questions. I love questions, by the way, so I hope you'll ask a bunch, which is the ethics of all of this. I know that even though it's becoming more and more common to comment publicly in cases, I know that there's still a lot of skepticism as to ethics. Do we skew the legal system somehow on behalf of who can spin better? And that's a real concern, a real problem. And I'm going to make the argument that that can happen. But what can also happen is you tilt the scales of justice in your favor. You level the playing field to a large extent. But let me start with the disciplinary rules regarding ethics. Specifically, there's New York State Disciplinary Rule 7-107, which says that a lawyer who is participating in a criminal or civil matter shall not make an extrajudicial statement that the lawyer knows or reasonably knows will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. That would seem to eliminate a lot of the work that I do at first blush. Until you consider what does materially prejudicing mean. If you're getting facts out about your case, and there's more, by the way, to that regulation I'll talk about in a minute. If you're lying about what went on, you're materially prejudicing the proceeding. If you're getting information out that is truthful, I'd argue you're not. You're getting information out that's truthful. By the way, the regulation goes on to say that you can say the following. You can talk about the claim. You can talk about the offense or defense of that claim. You can talk about information contained in the public record, including all the documents and materials that are attached. And you can make a public statement when warning of danger and you believe that there's a reasonable likelihood of substantial harm, including harm to the public interest. Now, if you look at a lot of cases that are commented on in the public domain, a lot of them have a big public interest element to them. Look at Goldman Sachs. Look at the Toyota case. I mean, look at any dispute involving healthcare, which impacts a huge section of our economy and has a huge public interest element to it. So there's a lot of leeway in there as to what you can say and how you say it. You know, it sort of begs the question, okay, you can find your way through the ethical guidelines on this, but morally does it make it right? And you know, many people believe that when you use these outside influences, justice suffers. Or to put it more bluntly, the immoral spin doctors use their black magic to somehow tilt the scales in one direction or the other. They twist and bend the law and the judicial process to their own ends. They allow the waves of public passion to swell and engulf the reasonable dispensation of the law and of justice. And that's just not true. I believe the opposite is true. Properly using these channels of communication can eliminate many of the advantages that money, ideology, influence, class have brought to our legal system. Particularly as new technologies lower the price of entry into interacting in the media. You don't need the level of resources that you used to conduct litigation and to do so in the public arena. That ability to get out there and have your voice heard ensures that even the faintest of voices can be heard. I'll quote again from Justice Kennedy in Gentile v. State of Nevada. Since lawyers are considered credible in regard to pending litigation in which they are engaged and are in one of the most knowledgeable positions, they are a crucial source of information and opinion. To the extent the press and the public relies upon attorneys for information because the attorneys are well informed, this may prove the value to the public of speech by members of the bar. If the dangers of their speech arise from its persuasiveness, from their ability to explain judicial proceedings, or from the likelihood that the speech will be believed, these are not the sort of dangers that validate restrictions. The First Amendment does not permit suppression of speech because of its power to command dissent. And we have this highfalutin view of judicial processes, and it tends to, when thinking about media, fall into two areas. In the days before cases were covered, people got justice. In the days since, they did not. They do not. We all know that that's not true. Our legal system, you can argue, has gotten better despite the influence of media and other public audiences. Or maybe it could be argued that the legal system has gotten better because of those changes. The days when the prosecutors would speak to the judges who used to be prosecutors, and then speak to the defense lawyers who went to the same law school, and they would all get together and decide the administration of justice. Those days are over. And our legal system has always been anchored in the practical realities of the world in which we live. Back in the day when the elites made law, the elites made law. And I quote Justice Oliver Wendell Holmes, who once said, "Theory is the dinner jacket you take off before changing a flat tire." Grand theories of justice may be at the foundation of our legal system, but let's not pretend that all of these extrajudicial realities haven't framed our structure over the years. I think that certainly media and public audiences have taken their place among all of these real-world factors. And they may now be among the most important of those factors. And I suspect that can be scary to a lot of people. It circumvents a lot of the other factors that have held sway over our judicial system. For centuries, the litigation was guided by those who had influence to properly frame the arguments and the resources to fight the battle long and hard. The party with the greater resources usually won. The party who was marginalized and had less resources lost. I don't actually talk much about the O.J. Simpson case in my work. Because to me, that was not a case, the first O.J. Simpson case. To me, that was not a case of media somehow influencing the legal process. It was a case of money influencing the legal process. O.J. Simpson was acquitted in that first case because he could go out and get the better lawyers and the better experts to put up against public servants, and in the end he made the better case. While it was played out in front of public audiences, I'm not so sure the public audiences themselves had that much of an influence over the case. And by the way, as an aside to that, he is now, of course, in jail, much lesser charge where he didn't have the money anymore. That sort of defense. And so, the world has changed. This new ability to appeal to broader public audiences in addressing legal matters has circumvented many of the traditional systems. Ultimately, though, I'm not so sure it's a bad thing for our legal system and for justice. And I would argue that in the media age, an attorney who's not tending to these elements of their client's case are probably doing a grave disservice to both their clients and to justice. And with that, I'll be happy to take any questions.
It's kind of the flip side of using public opinion to affect the law, but like maybe using the law to affect public opinion. Do you think the SEC's decision to bring the suit against Goldman Sachs has anything to do with the financial report bill coming out? I don't decide, but
I would suspect, without any specific knowledge, I'd say that that probably is the case. I'm not sure that the administration had any idea that it was going to happen. In fact, it seems that they didn't. But a lot of these decisions are motivated by scheduling consideration. It also is the case that this Financial Inquiry Commission was going to hold its meetings, and I believe that the chairman of Goldman Sachs was listed as a witness before charges were announced. That may well have played into the timing as well. I mean, it's amazing the timing. I'll give you an example. When Barry Bonds was indicted, if I recall correctly, it happened at the end, towards the end of November. His lawyers were shocked that he had been indicted, the timing of it. And I looked at the calendar and said, well, let's look at this now. The World Series just ended. Next week you go into Thanksgiving and the Christmas holidays. And by the way, the prosecutor indicted him. He's leaving his post on January 1. Why would you think it wouldn't be that way, based upon all those factors? So I think you see a lot of, again, extrajudicial factors going into the timing of this. Question?
I want to ask you about this commitment to truthfulness.
Yes.
And so the overall goal of litigation communication is to affect the perception of different publics that are relevant for the conduct of the case. And you say that the best strategy for that is finding within this voluminous information a coherent story that is truthful, yet of course also takes your client's side. Do you think, someone could say, well, okay, but maybe the best way to influence public perception for any public is not necessarily just through information that affects the cognitive outlook, but appeals to emotions, fears, anxieties, and that's the best thing to interject into public discourse. And that's less a matter of truthful information, and I think more maybe what might be worrisome about conducting a case in the court of public opinion is the court of public opinion doesn't really operate necessarily on the basis of reason and information, some might say, as opposed to the court of law, where there are all sorts of rules of relevance and so forth that are supposed to restrict discussion just to reason, law, and logic. So the court of public opinion is really fundamentally different because appeals to emotions, particularly fear, anxiety, prejudice, hatred, can sway a public's perception. So that it's really kind of a deal with the devil and not as you described, a way of advocating.
I mean, it's certainly, look, there are elements to that, but I would argue that there are elements to that within the judicial process itself. And, that sways to emotion, sways that go against the logic and reason happen in the courtroom as well. I think that, is emotion one of those things that you use in the court of public opinion as opposed to just the rational discussion of facts? Yes. Part of that is the reality of the situation. But it also is the case that happens within the courtroom as well. There's the old lawyers maxim that when the facts are on your side, you pound the facts. When the law is on your side, you pound the law. And when neither's on your side, you pound the table. And that comes from the experiences inside the courtroom. And it may be that it's better controlled within the courtroom. But I mentioned at lunch an intellectual property dispute I was involved with last year involving the most complex biologic, which is a drug made from a human element. The case was held in a small town in Texas, right in the heart of Bible country. The intellectual property lawyer for our side made a compelling case scientifically how his patent did not infringe. The other side got up, and a local lawyer from Texas quoted from the Bible when describing how it did. They won, we lost. So I'm not so sure that those appeals to emotion and ideas other than reason necessarily happen in the courtroom either.
I'm from the Maxwell School doing an MBA program, and just to give a quick background, I've worked in public relations and public affairs for the last close to 5 to 6 years in India and in Dubai. My question specifically is taking a cue from your take on ethics. Being a public relations or public affairs professional boxes you in a certain way. I think you have to defend your client in a way. For example, if your client is a large Dubai government entity, in which case, okay, I had clients who were Dubai government entities. They're laying off people because of the recession. And a lot of cases where it is not justified, the kind of compensation package or anything that's happening. So there's always this moral dilemma. Like, you know your client is in the wrong, there are business interests to protect, but you have to say, do right things which are contradictory. So how do you reconcile, personally, this is for a personal question, how do you reconcile this moral dilemma of defending someone who's not in the clear, but at the same time, okay, you can afford to resign the account, but you need your bills to be cleared.
Really?
I mean,
well, no, I agree.
There, I guess.
I thought you meant I can't.
No, not personally.
I'm check mine.
Yeah.
Books. I understand what you're saying. It's actually true for both lawyers and public relations people. I'm in a little bit of a different situation because it's a smaller firm. That's my firm, and I can pick and choose within obviously economic reason what is interesting to me and where I think that we can win. I mean, ultimately, both lawyers and public relations practitioners face that, where they have to make a decision as to what types of clients they're going to work for and what they're going to say. I think that it's the case in several situations. I've told clients, you know what the best PR strategy is here? Get the correct spelling of the plaintiff's name for the big check you're going to write. Make this go away. Because if you try to bend the truth too much, it breaks. And this notion that somehow, it's all spin and cover up really doesn't work, because in the end of the day, it kills your reputation, it kills your reputation of your client. So those are the types of things I tend not to get. So a question.
I've been a reporter here in Syracuse for a number of years, and over those years, there have been occasions when I've covered trials literally from beginning to end. But given what's going on today and probably will happen to the press, those days seem to be over. I'm extremely troubled by that. Do you share my concern, and what do you foresee as the consequences of that? In other words, the lack of, of press coverage of cases.
I am more concerned about the lack of trials more than the lack of coverage of trials. I mean, it's a separate issue, but how do you ever get to justice if things settle before you ever get to trial? I mean, with your specific situation, I find that even the wire service reporters don't cover every day of every case. Now remember, if it's an O.J. Simpson trial, you probably will get some media coverage. But perhaps the days are gone, but I will tell you a couple things that are coming in there. I'm amazed over the past year or two of the growing influence of the wire services in writing the first draft of stories. And I've been in situations where a lawyer has given a closing argument for 4.5 hours, and this is in New York City. And the New York Times, the New York Post, the Daily News, and Newsday all quote the same 3 paragraphs. And he'll look at me bewildered and say, how can that be? I said so much during that. And if you go back and look at the Associated Press wire service story that went out first, that's what quoted those sentences from it. So I think there will, and the other thing to remember is that you're beginning to see an enormous impact of bloggers and media covering court cases in a way that they've never been covered before, with access to the filings. I mean, in the old days, as a reporter, if you wanted to find out about a case, you had to go down to the courthouse and flip through the box to see what had been filed that day. You know, at least in the federal system with PACER, you know, you can, for the second edition of my book, I tested it out, and I could pull up everything filed in the Southern District of New York the day before in about 30 seconds with all of the attachments. And so even though you're not at the courthouse every day, you're still covering the cases very closely. And a lot of bloggers who are not, I mean, it's not gossip, a lot of these blogs. They're covering real legal issues very closely, and they're able to link to the actual documents and the actual exhibits in a way that you weren't able to in the past. So while you're losing that from the decline of the traditional media, I think there's something else happening there that's keeping that interest alive.
Well, could I just follow up on that?
Yeah, please.
Not to be argumentative or anything. I would contend that most bloggers are not professional as compared to professional reporters, journalists, whatever. And also, I've been a stringer for the Associated Press for probably 25 or 30 years. And that really has stopped over the last couple of years here in New York State because of change of management. In fact, I just found out last week when I was talking to an individual who's an executive with the Syracuse Post-Standard that the bureau chief here, who had been my boss, was laid off. So there really isn't anybody here in the Syracuse area for the Associated Press. But you're absolutely right that there are times when I'd cover something for the Associated Press and it would be on the state wire, it would be going national, and that would be what people could use. But again, my contention is if I'm not covering it, or if the Associated Press is not covering it, or if local reporters aren't covering it, there's a real void there. And I think the public is clearly the loser, along with, you know, the judicial system. But
look, and I certainly understand and agree to that. I just wouldn't I realize that it may be the fact that most bloggers are not professional or professional journalists, but you're really beginning to see a depth and level of sophistication in what they cover. I'll give you an example from the Duke lacrosse case. There was a blogger covering the case who went to find out about proper police procedure and whether it was followed in that case, went police department by police department in North Carolina to find out what the procedures were, reported that all back on his blog. And that is something that no media outlet anywhere would have the time or the resources to do. So I'm just saying I wouldn't discount that part of it. Yes?
I'm just sort of interested.
This will be the last question. No, I'm just kidding, bouncing. It's the last question.
Right. I'm just sort of interested in just speaking with yourself and with Jonathan Green, who came before. Both of you mentioned just that having a background in journalism helps. And one of the things that I've found just with regards to speaking to lawyers, within the confines of our craft, particularly for TV journalism, you can talk to me for 40 minutes. Likely I'm only going to use 15 seconds.
Right.
So I'm wondering how it is that you are, even in being open, because usually it's us chasing you guys down to get information, how do you construct, and maybe you can say this for the lawyers or future lawyers here, construct a 15-second soundbite that is going to give me sum up what it is you can use to sort of sway the public opinion, unless you are doing what I'm doing, and that's contacting me on a daily basis, beating my door down and saying, hey, I need to speak to you, and consistently hammer out my facts or the table, whichever one comes first.
Well, part of the problem is the way lawyers are trained to make arguments, where you make an argument as follows: point A, point B, point C, point D, maybe down to point X, and therefore conclusion. It's almost the opposite of the classic journalistic style, you know, in the inverted pyramid sense. So what you really begin to teach them is you have to lead with your conclusion and lead with what it's about, and then go into the detail. And the other part of that is training lawyers to pull themselves away from the forest, or from the trees and see the forest. A training I do with lawyers is I put them up against the wall, about an inch from the wall. And I go stand on the other side of the room, and I say, okay, tell me what you see. And they'll say, well, I see a crack, I see a paint chip, I see a pen mark. I say, okay, now ask me what I see. What do you see? I see a wall. Lawyers are viewing their issues like this all day, every day. And then a call comes in from a reporter, they immediately shift, and they naturally begin to speak in terms of what they were just thinking. If you're going to respond properly to the media on calls about complex issues, you need to decompress, figure out what the story is for this audience, which is vastly different from the story from the argument you're making in court on that particular day. And I can tell you that I've been doing this 20 years. Less than a dozen times have I ever taken a reporter's call immediately, because I'm always in the middle of something. And if I want to convey the proper message, I want to have a little time to decompress. So I'll always say, look, what's the deadline? What are you working on? I'll call you right back. Then I'll go into the office and I'll say, you know what? What is the message here? What is the story? Maybe we prepared it beforehand, or maybe we'll come up to the spot. And I've actually been in court during contentious cases in the back, scribbling out the message and memorizing it. So when I leave the courtroom, I have it prepared. So those are the types of things that we do.
With that, I'm going to ask you to join us for the reception, for further conversation, and to join me in thanking Mr. Haggerty.